Well, thank you, Chairman Leahy. Solicitor General Kagan, welcome back to the Judiciary Committee. Last year, I had the privilege of chairing your confirmation hearing for the position of Solicitor General. And while we had a spirited debate, I think we can agree we didn't have quite as much media attention at last year's hearing. Why is that? As I prepared for this week's hearing, I have been thinking about the role of the Supreme Court and the Constitution in our lives. Many people may say, to paraphrase our Vice President, why is this such a big deal? Why should I care? Does the Supreme Court really impact my life or my family? If you have children, if you work for a living, if you're a woman, if you vote, if you care about the air we breathe or the water we drink, you need to pay close attention to the confirmation hearing and the work of the Supreme Court. The Constitution has a very tangible impact on all our lives. It's the foundation of the rule of law that is supposed to protect us from the abuses of power, abuses of government, abuses of big business. We, the people of the United States, we, the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution of the United States of America. The authors of the Constitution understood the timeless idea of justice was paramount. As we gather this week to consider your nomination to be the 112th person and only 4th woman to serve on the highest court, my goal is to ensure that you have a clear understanding of how profound an impact your future decisions may have on the lives of everyday Americans. Based on our conversations, I trust you will put the interests of the American people and justice for the American people first above popular opinion or politics. I also will do all I can to ensure that the American people, whether you're watching the hearing at home, at work, or at school, gain a better understanding of how the Supreme Court, which has a duty to uphold the Constitution, really does affect your lives. The principles outlined in the Constitution are not some abstract historical theory. At its heart, our Constitution, the rule of law, is about people. We, the people. Let's start with families and children. I, along with millions of American schoolchildren, were denied a full educational opportunity in our schools because I was forced to attend segregated public schools. The Supreme Court and Brown v. Board of Education rejected the notion of separate but equal and helped move our nation forward towards a more perfect union. It was a young attorney from Baltimore, Thurgood Marshall, who argued that case before the Supreme Court. He later became the first African-American Associate Justice, and throughout his distinguished career, he was aided by energized law clerks, including our nominee, Elena Kagan. If you believe that you have a right to fall in love and get married to whomever you wish, you're mostly correct, but only because the Supreme Court intervened on the side of the American people when it ruled in Loving v. Virginia that interracial couples could marry. Indeed, prior to that decision, the parents of the current President of the United States, some members of the United States Senate and the Supreme Court could not have married in some states. If you believe that what you do in your home, in your bedroom, is your business and no one else's, especially not government's, you are correct, but only because of the Supreme Court decisions like Griswold versus Connecticut and Lawrence v. Texas reinforced our individual rights to privacy, keeping government out of the private consensual activities of adults. The Supreme Court was on the side of the American people when it ruled in Roe v. Wade that the constitutional right to privacy exists. The court ruling was not taking sides in the debate on abortion. It was stating that there are certain matters in which government should not interfere in the privacy of families. These landmark decisions and others continued a forward progression of protections for the American people against the abuses of power, particularly by an overreaching government. Such was the case when the Supreme Court ruled in Gideon v. Wainwright that the constitutional right to counsel in a criminal proceeding was guaranteed regardless of the wealth of the defendant. The Supreme Court gave the words equal justice under the law real meaning. Perhaps this decision was to be expected, since the oath of office declared by every federal judge makes it clear that he or she will administer justice without respect to person or do equal right to the poor and to the rich. I believe that our next Associate Justice in the whole Supreme Court should be guided by legal precedent and the best traditions of the Supreme Court in advancing constitutional rights for individuals against abuses of power, whether by government or business, even as our world continues to change and evolve. Justice Thurgood Marshall said in a 1987 speech, I do not believe the meaning of the Constitution was forever fixed at the Philadelphia Convention. To the contrary, the government they devised was defective from the start, requiring several amendments, a civil war, a momentous social transformation to attain the system of constitutional government and its respect for the individual freedoms and human rights we hold as fundamental today. Some changes have not been for the better. I've been troubled by the increasing number of 5-4 decisions over the last 5 years, in which a divided Supreme Court reversed decades of progress and precedent with rulings that side with powerful corporate interests rather than protecting individual rights. This trend was clearly shown in Citizens United, where the Supreme Court reversed precedent and overruled congressional intent, giving corporate special interests even more power and influence in elections. In the Ledbetter case, the majority of the Supreme Court protected employers over workers and gender discrimination, again reversing the clear intent of Congress. In another 5-4 split decision, Gross v. FBL Financial, the court made it easier for corporate America to discriminate against aging baby boomer workers. If you work for a living, if you're a woman, if you're worried that corporations may have by a louder voice in elections than hardworking everyday Americans, you need to keep an eye on the judicial legislating being practiced by this Supreme Court. Are you a consumer? Do you buy products for your family? If so, the Supreme Court in Legion, yet another 5-4 split case, should be of concern to you. Here, the court ignored long-standing precedent to protect big business to perpetuate price fixing. It was a ruling that put consumers at risk. Rapinos, another 5-4 decision, was a step backwards, this time for the environment, by reducing protection from wetlands under the Clean Water Act. If you're like the rest of us and wonder if BP will be held fully accountable for the economic and environmental devastation brought on by the ongoing oil spill in the Gulf of Mexico, you'll be equally alarmed by the Supreme Court decision in Exxon versus Baker, which imposed limits on damages that can be recovered in environmental disasters. Time and time again, by the narrowest of margins, this activist court has sided with big business over Main Street America, wiping away protections set in place by years of legal precedent and congressional action. As Justice Stevens stated in Citizens United, and I know Senator Durbin quoted this, I want to give the line that comes afterwards. This is Justice Stevens. Essentially, 5 justices were unhappy with the limited nature of the case before us, so they changed the case to give themselves an opportunity to change the law. There were principled, narrow paths that a court that was serious about judicial restraint could have taken. I join him in wondering just how and why those who profess to oppose judicial activism have voiced their support for these Supreme Court decisions in which justices have overturned long-standing precedent and substituted their own legislative voices for Congress, blurring the line between the legislative and judicial branches of government. Justice Stevens followed in the best tradition of the Supreme Court in advancing individual constitutional rights. Like Justice Stevens, Elena Kagan is a known consensus builder. She is also an unquestioned legal scholar, a proven leader, and a dedicated public servant. As someone who's worked my whole career to expand access to justice for all, I am particularly impressed by her record at Harvard of greatly expanding the number of law school clinics, which provide essential pro bono work for individuals who otherwise could not afford legal representation. I welcome the American public to these hearings as we open a window to the Supreme Court and shine a light on the critical role of the Constitution and the rule of law plays in our lives. I come to these hearings not solely as a U.S. Senator, a legislator, and a lawyer, but as a husband, father, and grandfather. Every ruling made by the Supreme Court that continues to uphold constitutional protections that keep my granddaughters safe and secure is a victory. Every Supreme Court ruling that opens the door to abuses of power by the government or big business by overturning long-standing precedent or reversing congressional intent puts all of our children and grandchildren at greater risk. I will do all I can within my power to protect my family and every American family from such risks. Solicitor General Kagan, I welcome you to these confirmation hearings, and I look forward to your testimony and responses to our questions.